Good morning or midday. It is 12:01 on March 12th. A beautiful day that the Lord has made outside. If you guys have been out, it is exceptional. So blessed by that. You guys don't mind logging in, and Madam Clerk, would you open it for the roll, please? Looks like everybody except the chairman can log in, so that could be an issue. Oh, there we go. All right, Madam Clerk, please take the roll.
Mr. Chairman, 8 members present. You have a quorum.
Thank you, Madam Chair. Before we get started, are there any special requests or things to bring before the committee this morning? Not seeing any. We do have a full calendar. I will start with the bills that we are rolling. We got House Bill 510 rolled 1 week, House Bill 960 being rolled 1 week, House Bill 992 is off notice, House Bill 1049 1 week, and House Bill 32 1 week without objection. Moving on to House Joint Resolution number 28 from Chairman Bolso.
Motion. Second.
Got a motion and a second, sir. You have an amendment traveling with the bill, I believe.
Yes, Mr. Chairman, I sure do. It's drafting code 004774.
That is accurate. All those in favor of adding the amendment on, say aye. All opposed, motion. Motion and a second for the amendment. All those in favor say aye. Aye. Opposed, say no. Amendment is on. You are properly before us, Chairman.
Thank you, Mr. Chairman. Good afternoon, members of the committee. Members, this proposed constitutional amendment presents a single question. Should the people of Tennessee have the right to decide whether their government can require them to undergo a medical treatment? That's the question that this constitutional amendment presents. It's an issue, this issue of medical freedom is one that obviously received some currency with the recent pandemic that we went through beginning about 5 years ago, but it's actually one that has been with us for quite some time. And we've got already in our state constitution, Article 1, Section 8 was called a law of the land clause, which is our version of a due process clause. And Thomas Jefferson, when speaking about our Constitution back in 1796, said that the Tennessee Constitution was the least imperfect of the state constitutions. And he said that in part because in the federal Constitution, the Bill of Rights comes at the end. It starts with Article 1, executive branch, Article 1, legislative branch, Article 2, executive branch, and Article 3, judiciary. Our Constitution starts with a Declaration of Rights. It sets out currently 33 consecutive rights that all Tennesseans have. One of those is this law of the land clause that I mentioned a moment ago. That is the functional equivalent of Section 1 of the 14th Amendment that was obviously made applicable to the states after it was adopted in 1868. But the question here is a simple one. We have a history in our country, a recent history, of the federal government attempting to impose mandates on the population. Many of you will recall the Biden vaccine mandates that, among other things, required employers of more than 100 employees to require that their employees be vaccinated or be tested for COVID over some period of time. That was ultimately stricken by the U.S. Supreme Court. But even in our lengthy past, we have a history of a Supreme Court decision, the Jacobson versus Commonwealth of Massachusetts case from 1905, where dealing with the issue of smallpox, the state legislature in Massachusetts actually passed a law that gave local boards of health the authority to require that all citizens, in that case, be vaccinated or revaccinated. That's something that in the city of Cambridge was done back in 1904, they actually passed a law that required all citizens to be vaccinated or revaccinated. And then when Mr. Jacobson refused to do that, he took the case up to the U.S. Supreme Court, which interestingly decided that the law was not in conflict with the U.S. Constitution. That is, even in 1905, the Supreme Court determined that a requirement that citizens be vaccinated did not violate the Due Process Clause. That is one reason why we need this protection in our Tennessee Constitution, because it is not currently there in the federal Constitution. And if adopted, this amendment would enshrine in our Constitution one additional liberty in our Declaration of Rights. It would say that every Tennessean has the autonomy over his or her own body, that the government can never force you to undergo a medical treatment of any kind, absent due process of law. And so with that, Mr. Chairman, I stand ready for questions.
Thank you, Chairman Bolso. Questions before Mr. Kenny? Representative Mitchell, you're recognized.
Yeah, thank you, Mr. Chairman. So in the Jacobson opinion, the safety, welfare, and well-being of the many is far more important than the few. So in a situation, I hate, I spoke with someone earlier in my office. I hate that we have now politicized living and dying and good health. When you got someone sitting beside you, your rights, as the old saying goes to the tip of your nose. Well, when you are spreading a disease beyond the tip of your nose that's harming others around you, and it could be life-threatening, and Jacobson's, like you said, is still good law today, 120 years later. So how do you justify that one person's actions could have such negative actions, even death, among their fellow citizens?
Chairman, you're recognized.
Thank you, Mr. Chairman. I can respond in two ways, Representative Mitchell. There are citizens of our state that may feel exactly the way you do, that this is something that a government should be able to do. It should be able to require citizens to undergo different kinds of medical treatments. But there are other citizens who think the exact opposite, that one's personal autonomy is sacrosanct, that you can never have a government force a citizen to undergo a medical treatment. And so that's why I brought this HJR, because it gives the citizens of Tennessee the choice. It's going to be their decision as to whether they allow their state government to force medical treatments or not. It's not something that we can decide in this committee today or even in this General Assembly. That's the first point, that it's something for the citizens of Tennessee to decide, regardless of how one feels about it personally. And then secondly, Representative Mitchell, I would say that the question to a certain extent presumes that a government, although well-meaning, is also all-knowing. And I think the events over the past 4 or 5 years have shown that the government can make very serious mistakes when it comes to medicine and when it comes to science. And I think most folks would rather depend on their own agency, their own intelligence, their own autonomy in deciding whether they should undergo a medical treatment rather than being forced by a state government to do so. And as a final point, I'll note that we are living in a time when many of the rights that the federal government over the course of time has taken away are being returned to the states. And this is something that we really should put in our state constitution, because that is the ultimate protection of our citizens against an obtrusive state government.
Representative, you're recognized.
Yeah, thank you, Mr. Chairman. But fortunately or unfortunately, you and I are representatives of those people of this state, and we've been given the duty to take care of the well-being to the best of our ability and the best of our knowledge, and the knowledge of science, the knowledge of the advancements in medicine, and and to go back to your one person theory. I hear in committee after committee after committee, most committees, there's even a prayer at the beginning of many committees. Well, I'm sorry, I just don't think it's too Christian just to worry about yourself and not your neighbor, and not what your actions, how they affect the person beside you, the person you go to church with, the person you're standing beside at the grocery store. Your actions medically in certain situations can be detrimental, if not fatal, to your neighbor, so I'm only going to worry about myself. Constitutional theory is kind of beyond what I hear in this General Assembly daily. So, I'll just have to oppose this, but I appreciate your discussion.
Thank you, Representative. Representative McKenzie, you're recognized.
Thank you, Mr. Chair. To the sponsor, so, and this is a real scenario. This isn't hyperbole. So if this gets into our Constitution, you're saying that a prisoner with an extremely infectious and airborne disease can refuse treatment because he or she refuses treatment.
Chairman, you're recognized.
Thank you, Mr. Chairman. Representative McKenzie, no, I am not saying that. Obviously, every right that we have is subject to due process of law. And in the case of a prisoner, when you've actually been convicted of a crime and put in prison, you lose certain of your civil rights, not just your right to vote, but obviously your freedom as well as other rights. And so when you look at the statute or the proposed legislation, I should say, as a whole, it's clear that the government has no right to force a citizen to undergo a medical treatment absent due process of law. But where there has been due process, where there's been a trial, where there's been a conviction, then obviously the case of a prisoner is very different from that of a free citizen.
Representative McKenzie.
I'll push back a little bit on that in terms of their rights. I feel that they have similar rights, but let's throw another scenario out there. I mean, real scenarios, not made up. Average dormitory at the University of Tennessee has about 350 rooms in it. And you're saying that if we know there's an outbreak at the university and we can isolate it to this dorm and it's whatever infectious communicable disease, we can't do anything unless we sue everyone in that dorm, go through due process to allow them to Department of Health or Public Health to come in and get this situation under control.
Chairman, you're recognized.
Thank you, Mr. Chairman. No, I am not saying that because under your hypothetical, you're dealing with a school that is run by the state government. Obviously, the state can decide whether there are certain requirements that students must meet in order to be enrolled in a particular school. So this statute, this legislation, applies to the population generally. It doesn't apply specifically to folks who are enrolled in educational programs where they have to meet certain eligibility criteria.
Representative.
Thank you. You know, we have 5 times the number of private schools in the state of Tennessee than we have public schools. So this is a real, and I don't remember anything that I signed for my son who is in public school that would allow the university to come in and do that, save notwithstanding this bill. This is entering into dangerous ground. I am pro rights, but this is a bridge a bit too far. You know, we can play Monday morning quarterback on this COVID-19 scenario. That happened under 2 presidents. We always throw out President Biden, but those same restrictions came under President Trump. So this is apolitical. I don't know why we choose to make this political. It is not political. Infectious diseases, no party, no race, no anything. So this is not a political conversation. So I wish we would stop referring to one president at all, just this disease or this latest one. But for us to have come through that and to be living and breathing today, I call it grace. I call it fortunate. And I think if something like this had been in place in the state of Tennessee, we would have had a very different outcome. So I'm sure this is a well-meaning piece of legislation, but a piece of a joint resolution to get us codified in the Constitution. But this one is extremely dangerous, and I encourage folks to read this closely and consider our votes.
Chairman.
Thank you, Mr. Chairman. My only response to Representative McKenzie would be that, as Representative Mitchell pointed out, this is not a new issue. This was an issue all the way back in 1905 in Jacobson versus Commonwealth of Massachusetts. And there you had a public health board require everyone to undergo a medical treatment. In that particular case, it was a vaccination. Mr. Jacobson objected, saying, I am a free person. I have individual liberty. I'm not going to do it. And that's why the case went up to the Supreme Court. So it's an interesting issue. It's an important issue. It is not a new issue, but it is an issue that the people of Tennessee should be allowed to decide.
Representative McKenzie.
Yeah, thank you. And but let's finish that conversation. And he lost at the Supreme Court, and I'm glad he did. Thank you, Mr.
Chairman Williams, you're recognized.
Thank you, Chairman. Thank you, Chairman Balso. I just had a clarifying question here. I've had the personal experience of having a student athlete in an institution of higher learning in the state during an unbelievable amount of pressure from the NCAA to adhere to a regulation that I think would be in direct opposition to your constitutional amendment. How would that play out if the NCAA decided that as being able to participate in any sport that you had to take a vaccine that you had moral obligations against to take that vaccine? Would this Constitution preserve someone's individual right in spite of the NCAA, or would they have to quit being a student athlete?
Chairman, you're recognized.
Thank you, Mr. Chairman. Unfortunately, Chairman Williams, the answer is no. This will have no effect on a private actor such as the NCAA. It only works on the state and its political subsidiaries, city, counties, school district, boards of health, things of that nature.
Okay. Is the part of the intent of your constitutional amendment to relieve the pressure of conformity as it relates to certain treatments or care that may be acceptable to others, so that someone could make their own informed consent decision as it relates to the facts that are before them at the time?
Chairman, you're recognized.
Thank you, Mr. Chairman. I think the short answer is absolutely. We want to preserve as much medical freedom, as much individual autonomy, as much individual liberty when it comes to medical decisions as we can. And this proposed amendment gets us one step closer to that.
Yeah. Well, I think one of the things that's good about a constitutional revision is that the bar is extremely high. Particularly, it has to be read in two general assemblies and then voted on by the people. So it's not like we're standing here saying to people that we're going to do this to them. The voters get to decide whether or not they want this to be a part of their constitution and a right to decide without pressure from another or a third party in that instance. And so I'm going to support your bill. I think it's a good first step. I do think it is timely, particularly what we've seen and heard and done to our population based upon the repercussions that we now know that we didn't know then. So I appreciate you bringing this bill. Look forward to supporting it.
Thank you, Chairman. Representative Mitchell, one last question. Do you have one?
Yes, sir. Thank you, Mr. Chair. Going back to Jacobson. So if someone approaches you on the street with a weapon, do you have the right to defend yourself?
Yes.
So under the same principle of self-defense, of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. This has been longstanding law for 120 years in this country, worked out well. We've eradicated many diseases, infectious diseases in this country until here lately when we keep bringing up things like this to, encourage people not to do the right thing. And I think it's, again, our role to encourage people to do the right thing. Thank you.
Chairman.
Thank you, Mr. Chairman. Let me, if I could, Representative Mitchell, point out an analytical distinction, between those two circumstances. When you're defending yourself against someone attacking you, you are exercising your own individual liberty interests. You are a voluntary actor. You're not being compelled by the government to do anything. In the other example, where you have the community forcing you to take a medical treatment, you have been deprived of your own individual agency, your own voluntary action. But given that it is an issue that obviously is capable of being disputed, it's an issue that the people of Tennessee ought to be able to decide.
Representative Mitchell, one last point.
Your weapon would be smallpox or measles or whatever infectious disease you are attacking everyone in the community with. And if the community cannot defend themselves against you, i.e. the vaccine that you would be required to take to stop you from killing multiple people in the community, what defense does the community have of self-defense?
Chairman.
Thank you, Mr. Chairman. Well, the obvious answer, Representative Mitchell, is that you've made several assumptions there. Number one, that the government actually has provided a safe and effective vaccine, which is very much in dispute. And then secondly, that one person who is in the midst of everyone else who's been vaccinated is going to kill numerous people. That simply is not true.
We'll come back to you, Representative Mitchell.
How many people do you know with polio?
Chairman Terry, you're recognized.
Thank you, Chairman. Thank you for bringing this. And this is something, obviously, for me. You weren't here when we had during the COVID epidemic and during that time, and I actually had several bills, or either amendments or some bills, sort of dealing with this. And so, I guess philosophically, I'm with you to some extent. Obviously, some of the stuff that I ran in my own committee got shot down. So I'm with you on that. But I need you to reconcile something with me that I had to do 2 sessions ago. And I ended up trying to place an amendment on a bill dealing with childhood vaccines. And my understanding, if this goes through, the children would be able to refuse, or the parents would be able to refuse the vaccines for their children to go to school. And so there was a bill that came through a couple sessions ago that it had like 6 parts on it. And my concern is you had somebody, we require kids, it's compulsory to go to school. And we're not going to lessen or abridge the rights and privileges of our citizens. And in that, it said those students could refuse, or their parents could refuse the vaccines. There's some other processes within that. And the amendment eventually that I had was, okay, you could refuse, but there was at least some safeguards for the students. And so my example is, you got little Johnny that's not vaccinated and may have whatever disease. He comes into school. You have little Susie, who is immunocompromised for whatever reason, got cancers, on chemo, whatever reason. She has a right and a privilege to be in that classroom. And now you have somebody coming in that puts her life at risk, life, liberty, and pursuit of happiness. How do we reconcile that with what you have here?
Chairman, you're recognized.
Thank you, Mr. Chairman. This way, Chairman Terry, if the government were to compel a student to go to school, and compel the same child to be vaccinated, that would be a problem. But here we have a circumstance where, although children are compelled to be educated, you're not compelled to go to any particular public school. You can have homeschool, you could have private school, you have other schools that are possibilities for the child. So if you have a government that is able to set the eligibility requirements for attendance and enrollment at a school, one such requirement might be a particular set of medical treatments or vaccinations. This bill would not undo that at all. It would simply give the government the inability, if I could use that term, to force any citizen or through the parents, a minor, from undergoing any particular vaccination or medical treatment.
Chairman, you're recognized.
So I guess clarify that for me. So, because that was a discussion that we had a couple sessions ago. And so are you saying that the person that's not vaccinated would not attend that school, or they would be told, you've got to go somewhere else? Is that what you're saying?
Chairman.
Thank you, Mr. Chairman. Yes, a school can set its own standards for enrollment, and some of those could obviously concern various kinds of vaccinations against childhood illnesses.
Any further questions?
Let me think about that.
Chairman Leatherwood, you're recognized.
Thank you, Mr. Chairman. I know this is a reaction to COVID. It caught us all off guard. I think if we were hit with something like COVID again now, we would all respond differently. Also, we have filled legislatively some of the gaps in individual liberty, which we really weren't aware that they were there until COVID hit. And I have supported those measures along the way. And here we've got a constitutional amendment to try and address other gaps that there might be, that might still exist in our law. I think we're better filling those gaps, any that might still be there, and I think there are some still there. We're better off filling those gaps legislatively, like we have done in the past. And one of the reasons I think this is true, we're taking a process we've used to address these issues where we could have them actually go into effect this summer, June 1 or July 1, as opposed to a multi-year process. And, if we've got important issues out there where people's individual liberties are at risk, I just don't think this is the best process to try and address those. And I just kind of quickly did some math up here. I know I'll just say it, I think quicker, sharper than me in many regards. And if my wife's watching, she's probably agreeing with that statement as well. But again, addressing problems legislatively, July 1 or whatever of this year, people might not understand the constitutional process, but I think it has to pass by majority in one General Assembly, 2/3 in the next General Assembly, which won't begin until 27, I guess. And then it has to get on the ballot. And I'm not really sure of all the requirements for getting on the ballot, if it has to be in a gubernatorial year or not. But just quickly, I came up with 2028 would be the time that any of these measures could be implemented. Is that when could these measures, if it succeeds in all the multiple steps, when is the soonest that this could be implemented?
Chairman, you're recognized.
Thank you, Mr. Chairman. 2030 in the gubernatorial election that year.
Okay. Well, that's actually, see, I knew you'd know this better than I did, but
Thank you, Chair.
to my defense, I'm just up here trying to figure it out real quickly. So I do have issues with the resolution, and I mentioned that to you previously. And why wait until 2033 to address issues that we could address July 1 of this year? So thank you.
Chairman.
Thank you,
you're recognized.
Mr. Chairman. If I might just add, Representative Leatherwood, I mean, these two things are not inconsistent. That is, having this body legislate to fill the gaps and actually preserve a right of medical freedom in our state constitution. In fact, when you look at the language of the bill, it's clear under Section B that, quote, the General Assembly has the authority to enact legislation necessary to enforce the provisions of this section, close quote. So I think the constitutional amendment process and the legislative process are not antagonistic, but complementary.
Chairman Leatherwood.
Yes, and I think that's true. We could move forward on both paths. But I know if you get it in the Constitution, it's obviously harder to change. So there are more safeguards with it being in the Constitution. I see that as well. But I think given Tennessee and this legislature having these things in the TCA, frankly, give you just as much safeguards in reality, if not in paper, and they can be implemented sooner. So thank you.
Chairman, thank you for the great discussion and conversations. Without seeing any further questions, Madam Clerk, will you open the vote? All those in favor of House Joint Resolution 28, moving on to House Full, say aye. All those opposed, no on the board. Madam Clerk, take the vote.
Mr. Chairman, 5 ayes, 3 nays, 1 present not voting.
The ayes have it. House Joint Resolution 28 moves on to Health Full.
Thank you, Mr. Chairman. Thank you, committee.
Next on the calendar is House Bill 1310 by Chair Lady Haynes. A motion and second has been. Madam, you should have an amendment, I believe.
Yes, Mr. Chairman, 4798.
Motion second. All those in favor say aye. Aye. Opposed? Ayes have it. You are properly before us, ma'am.
Thank you, Mr. Chairman. This is just a modernization and cleanup of the environmental health statutes. And the legislation does six things to aid in deregulation. First, this legislation will allow for the Food and Safety Code to be modified by rule rather than through statute. And this is a significant change because it will give the department more flexibility to work with industry partners to update and modify food code as necessary. Secondly, this legislation deletes duplicate statutes regarding the rented premises unfit for habitation laws. Removing this citation will result in a cleaner, easier to read code. Third, this legislation updates the definition of a campground to exclude RV parks with no group amenities and year-round tenants. Fourth, this legislation will allow for pool inspections to occur once every 3 months instead of the current once per month. And there's also an additional safeguard in place that would allow for the commissioner to deem more inspections if necessary. Fifth, this legislation decreased the number of inspections required for bed and breakfasts that are currently registered in the state. These bed and breakfasts would be inspected yearly, making it more aligned with the other rental properties in the state. And the amendment limits fee increases in proposed rules to no more than 3% per year and no more than 5% over a 5-year period. This was an amendment that was worked on in collaboration with the food and service industry. And the Department of Health worked with all the stakeholders, the hospitality, grocery stores, and convenience stores. Thank you, Mr. Chairman. I stand
Thank you,
for
Madam.
questions.
Madam Chair, any questions for the sponsor? Not seeing any. Madam Clerk, please open the vote. All those in favor of House Bill 1310, press aye. All those opposed, press no. Madam Clerk, please take the vote.
Mr. Chairman, 9 ayes, 0 nays.
The ayes have it. House Bill 1310 moves on to Health Full.
Thank you, Mr. Chairman and committee.
Moving on to item number 3, House Bill 843 by Chairman Haston. We got a motion and a second. No amendments, I don't believe, sir. So you are properly before us.
Thank you, Mr. Chairman. What this bill is 2 of my counties, Perry and Decatur, who are both distressed and at-risk counties, have hospitals that closed several years ago. They're thankfully in the process of being reopened. This bill simply designates these 2 hospitals as critical access hospitals while also helping ensure that future federal requirements are being met for those. That'll be glad to answer any questions.
Thank you, Chairman. Any questions? Chairman Williams, you recognize.
Thank you, Chairman Haston. I appreciate your bill. And for the record, I did say your name correctly this time. But
Thank you.
the reason for this is because there was a closure, and this allows you to open. I guess the question is what's necessary that you have to do this? Is it because there's a long drawn out process for approval to reopen, and this allows them to open up sooner?
Chairman, you recognize.
I'm not positive, but I don't think they ever had this designation to be able to get on equal footing with some of the funding requirements that come with this designation.
Okay.
So I'm not for sure if they lost that and it would be a long drawn out process, or if they never actually had this official designation to begin with years ago.
Okay.
Chairman, they never had the designation.
Okay.
So that's
Okay.
right.
All right. Thank you.
Any further questions for the sponsor? Not seeing any. Madam Clerk, please open the vote. All those in favor of House Bill 843, vote aye. All those opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, 9 ayes, 0 nays.
The ayes have it. House Bill 843 moves on to health full.
Thank you, Chairman and members.
We'll move along to House Bill number 498 by Chairman Hale. Got a motion second. There you go.
All right,
There you go. And you got an amendment, I do believe. And
4414.
for motion second, all those in favor of adding an amendment, say aye. Opposed, no. Ayes have it. You are properly before us, Mr. Chairman.
Thank you, committee and chair. House Bill 498 reestablishes a task force to examine provider reimbursement rates and provider recommendations to state agencies that conduct with providers in Tennessee. This legislation mirrors legislation from a few years ago, seeks to continue the good work done by the previous task force. The members of the task force will be appointed by the Speaker, Lieutenant Governor, and will serve without pay. So I stand ready for questions.
Thank you, Chairman. Any questions for the sponsor? Question's been called. Madam Clerk, please open the vote. All those in favor of House Bill 498, vote aye. All those opposed, no. All members voted, yep. Madam Clerk, please.
Mr. Chairman, 9 ayes, 0 nays.
The ayes have it. House Bill 498 moves on to health.
Thank you, committee and chair.
I believe you have number 5 as well, Mr. Chairman.
Yes, sir.
Good deal. House Bill 133, motion second, and we do have an amendment traveling.
Amendment 4235.
Got motion second. All those in favor say aye. Opposed, no. Ayes have it. You are properly before us.
I'm honored to carry this bill for a good friend of ours, Kevin Raper, that's recovering. And so he had asked that I would carry this bill. House Bill 133 extends an already existing pilot program for residential facilities for people with developmental and physical disabilities. The pilot program already exists for a facility in both the Western and Middle Grand Divisions, and this bill would just extend it to a singular facility in the Eastern Grand Division. The facility would actually be located in Representative Raper's district. And what the amendment would do is it adds in a reporting requirement for the participants of the program, as well as to clarify that the program cannot be extended until the reporting process is finished.
Thank you, Chairman. Any questions for the sponsor? Question's been called. Madam Clerk, please open the vote. All those in favor of House Bill 133, press aye. All those opposed, no. All members voted and changed their vote. There you go. Madam Clerk, please take the vote.
Mr. Chairman, 9 ayes, 0 nays.
The ayes have it. House Bill 133 moves on to health full.
Thank you,
Congratulations,
committee and
sir.
chair.
Item number 6 has been rolled. We covered that. 7 has been rolled. Item number 8, House Joint Resolution 149 by Representative Lynn.
Thank you, Mr. Chairman.
You
This
got
is
a motion and a
oh,
second.
I'm sorry.
You got a motion and a second. You are properly recognized.
Thank you very much. This resolution is actually a resolution this committee passed last year. I just renamed it Make Tennessee Healthy Again. And it's just a resolution to encourage Tennesseans to learn more about the benefits of minimally processed foods, the potential harm of industrial seed oils in your diet, the importance of sleep, and the importance of exercise. As we know, Tennesseans are, we're not great on the health scale, but honestly, since this committee passed this bill last year, I really feel like awareness has grown about the importance of eating minimally processed foods and staying away from the fried foods and all of that. And I think we're on the right trajectory. So
Thank you, Representative Lynn. I think we can name this Make Tennessee Healthy Act number 2. I'll be first and you can be second on that one and begin. Any questions before questions been called? All those in favor of House Bill or House Joint Resolution 149, press aye. Oh. All those opposed, press no. Madam Clerk, please take the vote.
Mr. Chairman, 9 ayes, 0 noes.
The ayes have it. House Joint Resolution 149 moves on to health full.
thank you, sir.
Number 9 has been rolled 1 week. Number 10 is off notice. Oh, not off notice. Yeah, we didn't get one yet. Did you get one?
Yeah, we took it off notice in the beginning, but
Okay.
I got an email from his office. That's all.
10 is off notice, but 9 was rolled 1 week.
Oh, no, let's second. Yeah, 10 is off notice. 9.
Let me double check.
Yeah, I had that down. 1 second.
Okay.
We'll make sure.
Small amount of money, not much.
We did it at the beginning. So if he wants to run it, we can reconsider our actions, but I got a notification from his office on Tuesday.
Okay. We do have a email from Tuesday that one was rolled. We did that at the beginning, so we can
1 week.
consider our actions if need be.
I'm checking with my intern because he knows more than I do. We rolling this 1 week?
Second.
I'm asking. So
We did get a letter saying it was going to be rolled. It could have been an accident on his end, but we can roll it 1 week if that's okay with you guys since we've already done it. But
will y'all be here next week?
sir,
Will you be?
we are here. We're here next week. We got another calendar. So
All right.
we
Let
can
me
do
roll
that.
because it may be a problem with the amendment.
Yeah, we can do that for you.
Okay.
Absolutely.
All right. Can I
Appreciate-
save my time slot to be first, or how does that work?
That's this guy here. He's
Thank you, Mr. Chairman.
yes, sir. Thank you. All right. Now we're on to number 11, House Bill 1280 by Chairman Hill. We got a motion second. You were properly before us, my friend.
Thank you, Mr. Chairman. House Bill 1280 creates the Medical Expense Relief Fund to assist the next of kin and the estate of individuals who are enrolled in TennCare at the time of their death. And with that pending any questions, I seek passage.
Not seeing any question before. Oh, Chairman Williams, you recognized.
Although a great explanation of the bill. So what are you trying to fix here? I mean, is the goal for someone who's deceased or next of kin that the state would provide a grant system to help them remedy their estate? Okay.
Chairman, you recognize.
Thank you, Mr. Chairman, and thank you, Chairman, for the question. The legislation establishes a grant fund that TennCare would go and seek first before they go after the estate of individuals who passed that owe TennCare for, in many cases, it's long-term care. TennCare historically, I think on average, and I don't want to speak for them, but as my understanding on average is recouping about $34 million a year from individuals that have passed that are on TennCare. And what this legislation will do is give them an option to not go after families and to go after a grant fund first before they take what little assets that these families may have.
Recognize, sir.
Would the grant fund, would the dollars in the fund would be appropriated dollars from the Tennessee General Assembly through, say, reserves from TennCare or a direct appropriation?
Yes.
Okay. Thank you.
Yeah, thank you, Chairman.
Now, seeing further question, Madam Clerk, do you mind opening the vote? All those in favor of HB 1280, press aye. All those opposed, no. Madam Clerk, please take the vote.
Mr. Chairman, 9 ayes, 0 noes.
The ayes have it. House Bill 1280 moves on to health full. Get it now. Let's see. Item number 12 has been rolled 1 week. So we're on to House Bill 830 by Chairman Terry. Got a motion second, and we do have an amendment, I believe.
Drafting code 3503, I believe.
That's correct. Motion second. All those in favor say aye. Aye. All opposed, no. We are properly before us, Chairman.
All right, thank you. In 2021, the General Assembly created the Medical Cannabis Commission to develop and recommend a medical cannabis program for Tennessee. Since then, the commission has struggled to conduct business due to frequent quorum issues, and this bill will address that issue so that the commission can work to accomplish its purpose. The bill has 2 sections. The first section reconstitutes the governor's appointments by removing the requirement that one appointee must come from each grand division and expanding the eligibility to include caregivers. So that this change ensures better participation as many patients with qualifying conditions face challenges in serving. And then secondly, the second part with ongoing discussions about rescheduling cannabis at the federal level. The second section of the bill clarifies that the commission can make policy recommendations which would allow Tennessee to proactively develop a program to be ready to take effect if federal law changes.
Thank you for that description. Any questions for the sponsor? Not seeing any. Madam Clerk, please open the vote. All those in favor of House Bill 830, press aye. All those opposed, no. Madam Clerk, please take the vote.
Mr. Chairman, 9 ayes, 0 noes.
The ayes have it. House Bill 830 moves on to health full. And this will bring us up to item number 14, which is House Bill 1044 by Chairman Terry. Got a motion and a second, and you do have an amendment with us as well.
Yes, the amendment is drafting code 3991.
All those in motion and second, all those in favor say aye. Aye. Opposed, no. Ayes have it. You are properly before us.
All right, thank you, Chairman Committee. The Medical Ethics Defense Act safeguards the rights of doctors, pharmacists, nurses, and medical students to practice medicine in alignment with their moral, ethical, and religious beliefs. With the amendment, this does not apply to procedures, treatments, or services governed by federal law, so that includes EMTALA. It does not apply to a healthcare professional or healthcare institution when performing healthcare procedures, treatments, or services for any individual who is in imminent danger of harming themselves or others, and establishes that healthcare payer may not decline payment for a healthcare procedure, treatment, or service it is contractually obligated to pay for under terms of a contract with an insured party. This type of law has been passed in several other states, including the blue state of Illinois and the red state of Mississippi for decades. And they've had that in place without issue. I do want to go on record that I would consider this a Hippocratic Oath Protection Act as well. I say that because as a physician, I have an ethical and moral principle to do no harm. Yet if I'm asked or required to participate in something that I believe may harm a patient, I may be placed in a moral dilemma. So we are facing a major physician shortage in the nation. The AMA is projecting anywhere between a 37,000 and 124,000 physician shortage by 2034. The Association of American Medical Colleges is projecting around a 90,000 physician shortage. And part of that reason is due to burnout. And burnout, one of the issues within burnout is something called moral injury. And moral injury to a physician is when a physician is essentially, there's different types of moral injury, but when they're required to provide a substandard care due to various constraints like prior authorization or medication or product or equipment restrictions. But it's also when a physician, particularly if you're an employed physician, if you're asked or required to participate in care that you may believe may harm a patient. And so to give you an example, as an anesthesiologist, if I believe that a patient isn't suitable for surgery, it may not be safe for them to go to surgery. I may go to a surgeon and ask to postpone the case due to patient safety. The surgeon may go to the administration or to my employer and file a complaint. And then that's the term for that's called weaponized reporting. And so now I may be in a moral dilemma, stuck between caving in and potentially putting a patient at harm, or having this on my record or in my file, or potentially losing my job. So this bill addresses that issue and is going to place Tennessee in a better position to recruit and retain physicians while allowing us to advocate for patients. And so I ask for your support.
I greatly appreciate this bill. We do have a speaker who traveled with us, so without objection, if you would mind letting her come and speak just briefly, I believe. Yes, ma'am, there you are. If you don't mind, come up to the mic and just present your name, and you'll have 3 minutes. Oh, sorry, we have you over here at that seat, if you don't mind.
How's that?
You're perfect. And just state your name for the record, please.
Yes, my name is Erica Steinmiller-Perdomo, and I serve as an attorney at Alliance Defending Freedom. And thank you to Chairman Martin and distinguished members of the committee. I'm pleased to speak to you today about this important piece of legislation, the Medical Ethics Defense Act. Alliance Defending Freedom has represented medical professionals across the country who have been forced to risk their livelihoods or be forced to violate their deeply held ethical, moral, or religious beliefs. Some doctors might be willing to do a controversial treatment, while others might find that same procedure unethical. And we're seeing a disturbing trend as nurses or doctors are disciplined and even fired when they express a conscientious objection to a specific non-emergency medical procedure, treatment, or service. For example, we represented a nurse practitioner in Virginia, Paige Casey, who was fired from a CVS Minute clinic because of her conscientious objection to dispensing abortion-inducing drugs, despite being accommodated without any problem for patients or coworkers, and successfully being able to do her job for over 3 years. And even here in Nashville, we represented in 2011 a prospective nursing student for the university, for Vanderbilt University. She wanted to apply for the nursing residency program. But in order to do so, the application required her to pledge to participate in abortion. And this was a pro-life young woman. And we filed a complaint with HHS to expose the discriminatory practice by the university that would effectively eliminate pro-life nurse practitioners as students or graduates from the university. The very next day after we filed that complaint, Vanderbilt changed its policy and no longer was requiring students to pledge to participate in abortion. But still, 1 in 3 Christian medical students experiences discrimination or pressures during medical school. And HB 1044, the Medical Ethics Defense Act, would address just that situation by protecting healthcare providers from being forced to do specific non-emergency procedures that violate their deeply held beliefs. It ensures that even as a doctor or health clinic may decline to perform an ethically problematic procedure, they'll still serve a patient with all their other healthcare needs. So I want to be clear that there's no right in this bill to refuse to serve a person because of a specific trait, characteristic, or assumption about their lifestyle. There are already legal protections against discrimination based on race, sex, national origin. And this bill does not change that. But the conscientious objection here has to be based on a specific procedure itself. The bill's clear that you can't have a conscientious objection to providing emergency services. So that's consistent with federal law, EMTALA, that requires physicians in emergency situations in emergency rooms to provide medical treatment or stabilizing care and transfer a patient.
Yes, ma'am. Your 3 minutes is up. Thank you very much, though. You're good. Yeah, absolutely. Quick question, Representative Mitchell, or McKenzie, you're recognized.
Thank you, Mr. Chair. So, and you were getting to it at your last. So if a woman came in and had to have her pregnancy terminated due to protection of her life, this bill and your organization would not stop that. Is that, or would not be offended by it from your organization, and then this bill would not stop that. Would allow that doctor to do his or her Hippocratic oath and perform that service.
So I want to be clear, when you're talking about a termination of a pregnancy, there is spontaneous terminations of pregnancy due to a miscarriage or a treatment for an ectopic pregnancy that arises in emergency situations. And there is, medical professionals are not, typically do not have conscientious objections to providing that type of life-saving treatment. If you're talking about an elective abortion, a provider would be protected from having to participate in an abortion procedure.
Representative McKenzie.
Thank you. So let me be clear. We're not talking about an elective abortion. That's not what, take that off the table. We're talking about a lady comes in and this pregnancy puts her life in immediate danger. I don't want to throw. We got a lot of lawyers here. I'm not one of them. I'm saying her life would be in serious jeopardy if not for a procedure which would result in termination of the pregnancy.
Yes. Oh, Chairman, Representative. Yes, so Tennessee law does provide for abortions in emergency circumstances, and there are many doctors available who can provide that care to a woman if she needs it. But there are doctors who practice medicine consistent with a pro-life worldview in which an abortion is never medically necessary, and there are procedures that are available in order to treat a woman in that kind of circumstance without having to perform an elective abortion.
Thank you, madam. No further questions. Yes, Chairman Terry, you're recognized.
Thank you. And since I'm on the committee, I can ask you a question. And so I just want you to clarify this. These laws have not been challenged in court, nor has there been a single documented instance of anyone in those states that have been unable to access sought-after healthcare service. Is that?
Chairman, Representative, that's correct. 7 states have passed laws like this, including Illinois, Ohio, Arkansas, Mississippi, South Carolina, Montana, and Florida. And none of those medical conscience laws have ever been challenged. And there has been no documented instance of a patient in those states being unable to access sought-after medical care because of laws that protect their medical providers' rights. And in fact, laws like this lead to more physicians being able to enter the medical profession with their integrity and their ethics intact. That means more physicians in the field to address the shortages that Representative Terry mentioned, more physicians providing more services in more hospitals and providing care to more Tennesseans. Thank you.
Thank you, ma'am. Without seeing any other questions, we'll go back in session. Thank you, ma'am. We are back in session. Any further questions for the sponsor? Not seeing any. Madam Clerk, please open the vote. All those in favor of House Bill 1044, vote aye. All those opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, 7 ayes, 2 nays.
The ayes have it. House Bill 1044 moves on to healthful. Without anything else before us, this committee stands adjourned.